Good morning, Your Honors. I'm Leslie M. Conklin, and I represent the appellant South Bay Lakes Homeowners Association, Inc. We're here on review of an order of the lower tribunal denying a motion for attorney's fees pursuant to 57105. The record in this case is rather interesting in that Wells Fargo, the appellee, filed a total of 2 pleadings in the entire case, a notice of lis pendens and a complaint, and they got them both wrong. Both are wrong. First, the notice of lis pendens. They say in the notice of lis pendens, Wells Fargo is foreclosing the property described in the mortgage, recorded in cites an OR book and page number, and then they have a description of the property. It's the wrong property.
This thing, historically, the first mortgage had the wrong
Legal description.
and they did some modification on a document thereafter, and then the lis pendens picks up the old address rather than the new legal description, right?
Correct, but it was more than that.
Are both of those addresses in South Bay Association?
No. The other one, which is Lot 60, is in a completely different subdivision, which was developed by Beezer Homes, which was the original lender and developer of the properties. So no, they're completely separated. How that mistake was made, I'll never know, and we'll probably never know. But they corrected it by the modification. But the interesting part was in the foreclosure itself, they don't correct it. And this is what the judge, in denying the motion for attorney's fees, and he says, well, it isn't frivolous. They had the right property because they alleged the modification. That isn't what the complaint says, though. The complaint says in paragraph 4, the mortgage was recorded on January 18, 2006, et cetera, and mortgaged the property described in it, then owned by, in the possession of the mortgagors. A copy of the mortgage is attached as Exhibit A. Mr. and Mrs. Jankowski never owned that property, and had never mortgaged that property because it was the wrong property. They don't, and then, paragraph 5, they say plaintiff as servicer, and if you'll recall, I mentioned that in the reply brief. And then it is until 5A that they say the above referenced mortgage and note were modified by virtue of the modification, and they do attach that. So I guess we're led to believe that they would have caught this error before. I tell you, I don't think so. And I would hate to think what would have happened had I not raised these defenses. And the interesting part is...
Let me ask you a couple things about the record.
Certainly.
You apparently filed requests for admissions to which they did not respond, and you described those in your motion for fees or something, but at least in our record there's no copy of the request for admissions. Is that in the record below and it just didn't get moved up here?
It's in the record below, Your Honor, and I'll tell you the truth, I probably should have brought it to your attention, except for the fact we're really not on appeal of the final judgment of foreclosure, or the final judgment dismissing the lawsuit. And the judge, by the way, in his order references the request for admissions.
And did that final judgment dismiss this entire lawsuit or only as to South Bay?
And the entire lawsuit, Your Honor.
Okay.
Now, the interesting part, though, is, Your Honor, and I do this every time, in the motion for summary judgment, which is in the record, at page 2, I recited the request for admissions verbatim. So in other words, when they didn't respond to the request for admissions, they actually had 2 bites at the apple. They had it when I originally served the request for admissions, and then they had another opportunity when I served the motion for summary judgment. And as I stated, they only filed the 2 documents, so they didn't file for relief from the admissions. And here's the part, and this isn't the first case that I've brought before this court on appeal on this issue, and that is, judges deny my motions for 57105 when they previously, in the order dismissing the case, found that the requests for admissions were never responded to, that the matters set forth therein are conclusively established, and then overlook all of those facts when we get to the attorney's fee portion. I don't know how that happens. I don't know how that's not part of the record. I don't know how we suddenly close our eyes and, they're no longer in existence. That has puzzled me. The second thing, and by the way, I pointed this out not only in the motion for 57105 that they had the wrong property, I pointed it out in the affirmative defenses, I pointed it out in the motion for on the effect of the Rule 1.370. In 4 separate pleadings that I filed, I pointed out you have the wrong property.
Arguably, the complaint apparently has the right property and the lis pendens has the wrong property. Is that how this would be?
No, I disagree with that. And I've just read from the complaint. The complaint references the original mortgage. But they do
And
attach.
they attach
They
the
do.
modifications.
They
So,
do.
If you read through everything, you can eventually at least figure out what it is they think are foreclosed.
Except for the allegation in the complaint that says, then owned by, mortgaged and then owned by the Jankowskis. The point being, they didn't own it. That should have been in 5A, not in paragraph 4. Nonetheless, for the court to say, no, they had the right property, it's like, if that was the case, why after 4 pleadings that I sent to the other side, why didn't they correct it? Why didn't they amend the notice of lis pendens? And what about the poor sucker that owned lot 60 in the other subdivision? I mean, we don't say anything about that. They say, oh, this was all part of the plan, or nothing was wrong, it was okay in the complaint, and the point was, then you went ahead and slandered somebody's property in the notice of lis pendens for no reason? I don't think so. They didn't understand that they had the wrong property. They just didn't. The second thing was, the lower tribunal denied the motion for attorney's fees and said, oh no, I don't think it's frivolous because the homeowners, the Jankowskis, admitted that they owed the debt. Didn't even reference Wells Fargo, by the way, in that quote. The exact quote from the court is, the defendants, Mr. and Mrs. Jankowski, in this case never questioned that they didn't owe the money. They disputed, what their answer said is, we dispute the amount we owe, so I don't think it's frivolous. That's on page 27 of the transcript. This is the answer that the Jankowskis pro se filed. Nowhere in it does it have the words Wells Fargo. And in fact, it just says, we are disputing the amount owed on our property through America's Servicing Company, has an address.
Now, the correct address of the owners, I'm sorry, I'm forgetting their names, Jankowskis?
Jankowskis, I think it
is within your homeowners association.
Yes, that's correct.
And, I mean, admittedly, this foreclosure action was not cleaned up in any fashion, but it sounds as if it could have been cleaned up so that a proper bank was suing the Jankowskis on the proper piece of land inside your homeowners association.
Correct.
And under those circumstances, your lien for dues or whatever would be foreclosed. Is that right?
Correct.
In this case, was stayed for a while for a bankruptcy, and I'm sort of betting all these things got taken care of there. But
I would presume so, Your Honor, but I can't say that standing here today.
So
I have no knowledge of a refiling of a foreclosure case in this instance. Anyway, we get to the answer brief, Your Honor, and I make some mention of that in my reply brief. And Wells Fargo originally sets out in their answer brief, and they say, well, this is all answered because, and I'm quoting from their brief at page 2 of the answer brief, the Jankowskis admitted in their response to the foreclosure complaint that they owed money but disputed the amount to America's Servicing Company, the loan servicer for the appellee plaintiff, Wells Fargo Bank, N.A. I don't know where they got that in the record. That's nowhere in the record whatsoever. There is an Exhibit C attached to the complaint because they lost the note. No note was ever attached in this case, and there is one sheet from America's Servicing Company.
Was there a copy of the note? There was a count for establishment of a lost note.
Never.
There was never even a copy of one.
No, it was an Exhibit C, which is basically a snapshot of a computer screen, and it has at the top America's Home Servicing, or whatever it is, and it sets forth what the terms are and how much is owed. But the point being, that's never related. Here's the interesting part, though. By page 7 of their brief, they're no longer even referring to America's Home Servicing as the servicer for Wells Fargo. Instead, and I'm quoting from page 7 of the brief, the defendant borrowers, Jankowskis, did not contest they owed the plaintiff Wells Fargo money, but only contested the amount due to plaintiff Wells Fargo. They repeated it twice in the same sentence. The point being, at no point in that answer that I just held up does it say Wells Fargo. And at no point in the complaint do you find that America's Home Servicing is the servicer for Wells Fargo. In point of fact, in paragraph 5 of count 1 of the complaint, they allege, and I'm quoting, Wells Fargo alleged they were the servicer for the owner acting on behalf of the owner with authority to do so. So the point being, which is the truth? What they raised for the first time in their brief, and that was America Home Servicing was the servicer for Wells Fargo, or what they alleged in the complaint, Wells Fargo was the servicer.
Well, is that really relevant to your appeal, though? Those are issues that would have been fleshed out below had the foreclosure continued.
Exactly, except for the fact that the trial court then says, I don't think it was frivolous because the Jankowskis admitted that they owed the money. Judge, by the way, didn't even reference Wells Fargo or America Home Services.
They disputed the amount, they agreed with the debt.
Correct, but I'm saying that's not the issue anyway. The issue was who held the note of mortgage. It wasn't whether the Jankowskis executed the note of mortgage, it wasn't whether they paid the note of mortgage, whether they defaulted under the note of mortgage, who held the note of mortgage.
Well, was there a dispute that the homeowner's lien would not have taken priority over the mortgage if it was ever connected to the correct parties?
No. Keep in mind, they never filed a reply to the affirmative defenses. And in the affirmative defenses, I did allege the statutory, claim for the 1%.
Yeah, you would have bumped somebody else off, but not the bank.
Correct.
Okay.
But
were some of these other people served? Because at least in
the Jankowskis were served.
Our record on appeal probably doesn't include some of the miscellaneous documents in the trial court below. So were there defaults entered against any of these other people in this case?
No. 2 pleadings were filed by Wells Fargo, notice of lis pendens, the complaint, no motions for default, and of course the Jankowskis filed a response. They filed that 1-page pro se answer saying, we dispute the money owed, and we're trying to work it out with America's Servicing Company. Well, anyway, the point is, Judge, you're correct. That's not the issue. The issue was who held the note of mortgage. In the answer brief, they cite the case of Tentman versus City of Miami. And that particular case, Your Honor, the ruling by that court was, and that was pre-1999, 57-105, but the ruling in that court was they approved a final judgment awarding 57-105, quoting the 3rd District, quote, there was no way on this record that the plaintiffs could have ever shown standing to bring this lawsuit or could have otherwise succeeded on the merits. And the point being...
So you basically ended up becoming the de facto lawyer for the homeowners.
Basically.
In question. Because you did all the work that their lawyer should have done, and it's not fair that you don't get compensated for trying to clean up this whole thing to make sure the homeowners association lien has the proper protection.
Exactly. And my only way of getting the attorney's fees is...
There's no other way to get fees except 57-105.
That's correct.
And you filed your motion, or the court could have had inherent authority to award attorney fees under its own motion.
Absolutely. If nothing else, for 57-105-3 for failing to respond to the discovery. The point being, yes, I succeeded on the case and then lost the war on the attorney's fees. By the way, I want to point out one other thing, and that is at page 8 of the answer brief. I mean, Wells Fargo in their brief went on, and I quote, also, contrary to appellant's statement at the last paragraph of page 17 of its initial brief, and as shown by the allegation contained in the foreclosure complaint, plaintiff's counsel was advised by its client, Wells Fargo, via written referral instructions to foreclose, that it owned the promissory note of mortgage pursuant to an assignment of mortgage that just needed to be recorded. The fact that the assignment of mortgage to plaintiff Wells Fargo has just recently been placed of record effective prior to the filing of the foreclosure case evidences Wells Fargo's records did not lack the material facts to establish standing. Where in the world in the record did that come from? There's an affidavit in the file filed by the Homeowners Association that there was no assignment of mortgage recorded as of the date of the affidavit. And the point being, this is like the Bank of New York case that I've cited, and they complained and said, oh, you're trying to pass that off. It's a 57-105 Section 7 case. It was. But the court in that case, in the Bank of New York versus Williams, said, we've dismissed as to all parties. That's the first thing that's significant about that case on a standing issue. Remember, the Williams brought it up that it was standing. And the second thing that was significant, they said, Bank of New York defended in that case on the 57-105 and said, well, we have the note of mortgage, and when we file our new suit, it'll go along just fine, so it's not frivolous. And the court in the Bank of New York said, that's the next case. Right. But as to this case, you owe 57-105 fees.
But the standard review is discretionary, right? Abuse of discretion.
That's correct.
where is the abuse of discretion? Basically, you're saying as a matter of law, that court had no discretion to deny your motion for fees.
In at least 5 cases by appellate courts, including the Florida Supreme Court, the courts have said you shall award attorney's fees when it fits the statutory criteria. The problem is circuit judges don't...
Under subsection 1.
That's correct. And it says shall. And the point being, what in the record shows that they would have ever succeeded on standing? Maybe in the next case, but nothing in this record.
In this case, they allege that Wells Fargo Bank is the holder of an assignment that is going to be recorded, and immediately it became undisputed that they did not have an assignment, it was not recorded, that they had no basis to go forward with this lawsuit. Right?
Well, correct, Your Honor. I went forward on my motion for summary judgment.
Because they didn't take a non-suit of the case after they apparently determined that Wells Fargo wasn't the proper person to be bringing this lawsuit.
They did nothing further, Your Honor. Okay. Thank you, Your Honor.
I'll give you 4 minutes for rebuttal.
Thank you.
Good morning. My name is Forrest McSurdy. I am counsel for Appellate Wells Fargo Bank. This case is an example of what has happened in the foreclosure industry and in the legal industry over the last few years with respect to handling foreclosure cases. The courts now are just beginning to realize what has happened in terms of handling these cases. In 2009, 2008, when these cases were coming out from the banks were inundating foreclosure firms with tens of thousands of foreclosures saying, rush, 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 file, file, file.
How is that going to help us?
I'm giving you a background of what happened
No, I
here.
just, we've all read the newspapers. I mean, that's,
Right.
you're asking for sympathy?
No, not at all, not at all, not at
The
all.
problem here is that
Not at all.
this man has become basically the lawyer for everybody in this case. He's done the homework that should have been done before the lawsuit was filed, and now the people who filed the lawsuit don't want to pay the lawyer that did the work that their lawyer should have done. Right?
Well,
After they were given notice, they hadn't done it.
I'm sorry, Your Honor.
After they had received notice that they hadn't done it.
Well, actually, that's a point that
You're suggesting when you get a request for admissions and you don't even respond to it, telling you don't have the proper documents, and you never respond to show that you do have the proper documents, that you're not on notice that you don't have the proper documents?
Well, actually, I checked through the file, and there were no copies of the request for admissions in there. There was no copy.
You're suggesting there was a request for admission file?
In the court file, there's no request.
No, in our file.
So you didn't.
The
So you're
attorney-
saying your client did not receive the request for admission?
Correct, Your Honor. Nor did they receive a
You
copy.
raised that, but you didn't raise that at the time of the hearing.
We didn't get a copy of the notice of hearing, Your Honor. We weren't the hearing was not coordinated by Mr. Conklin. I finally refer to Mr. Conklin as Mr. 57105. He's never met a case that he does not feel 57105 is appropriate.
Wait, just please don't get personal.
No, I'm not. I said finally and with
We're not doing us
respect.
any favors by going outside
You've
the
got
record.
one case here.
Yes.
We're taking this case rather seriously, sir. All right?
I am too, Your Honor. His first point with respect
Your
to...
allegation is that he signed certificates of service and didn't actually send you...
That's in the transcript, Your Honor, that the attorney handling the case at page 16.
You all sent an attorney who'd never seen the case before the day of the hearing.
I was embarrassed by it. This case was sloppily
embarrassing,
handled.
yes.
It's candidly, it was sloppily handled
So I don't
by the
see
foreclosure
that-
attorneys.
I mean, is there anything in this file to establish that he violated his duty as a lawyer concerning certificates of service?
Is there anything in the case
Yeah.
other than that the transcript reflects that we did not get notice of the hearing, and the judgment itself reflects that no one appeared for the hearing? It just strikes me as strange. That's in the record, Your Honor.
So because every time there's a hearing, your law firm shows up for the hearing.
Yes, that's a matter of standard practice. We get
But when
notice
you
for a
got
hearing.
this final judgment, you didn't move for rehearing on the grounds that you didn't know anything about the hearing?
We didn't get the notice of judgment until after the 10-day, 15-day period had passed. And the notice that was
court
evident
didn't
in the
send you the
file
final
was the
judgment
motion
for-
for attorney's fees. We did get the motion for attorney's
You're also
fees.
claiming then that the court didn't send you the final judgment in a timely fashion.
Correct. I don't know if Mr. Conklin
Do
was...
we need to have an evidentiary hearing below to find out what the court did and what...
No, I don't think that the main point, Your Honor, is whether the trial court had a reasonable basis to determine whether 57105
Well,
was.
if you made a finding there was no notice, that's one thing, but if, without that being a finding,
That was not raised below, so I don't, other than in the transcript itself. And I did not raise that in the, but you had asked, why didn't you appear? So I felt it was appropriate to respond. That's why there was no appearance. So it wasn't as if we said, this is not important, we shucked off that request for admission. That's not our way of handling things. But our file and the transcript reflects, and the judgment itself reflects, no one appeared for the hearing, and I'm telling you why.
there was no basis once that 10 days had filed for you to move under some rule to get this set aside because the other attorney had basically committed a fraud on the court by signing a certificate of service that wasn't true?
Well, but we didn't know that was necessarily true. We also, it might have been a mail problem, Your Honor.
You apparently did have notice of the 57105 motion.
We did. We definitely did get that.
Because you did send a lawyer to that.
Yes,
And that lawyer was unprepared to present any of the facts associated with the representations that you are now trying to make to this court, right?
other than what was personally said to him that no one had coordinated the hearings below, and that's why the final
But you
judgment.
didn't know that for a fact, and it wasn't presented by affidavit?
No, it was merely his oral argument to
And
the
I want to make
court.
sure I've got you clear. You've used, several times you've used, no one coordinated the hearings. Is that the same thing as saying, and no one sent us a notice of hearing?
With respect to the final judgment, summary judgment?
As to the hearing on where the judge dismissed foreclosure.
Yes, our file does not reflect.
Because you've used that kind of interchangeably. All right, when you said no one coordinated the hearings, that means they didn't call us and get us a clear time before they sent a notice. Or are you telling me that they did not even send you a notice of hearing, and that the reason no one appeared at that foreclosure hearing is because you didn't get a notice the hearing was held?
What I'm saying, Your Honor, is no one called to coordinate the hearing.
Okay, that's one
And
thing.
we
Now, let's
did,
go to the
and we
next
did
step.
not receive a notice of hearing.
You did not,
We did not
receive a notice of hearing.
receive. Now, whether Mr. Conklin sent it or not, whether our mail was not received, I don't know.
basis to go in and get some type of relief even after the 10 days is filed?
Well, it had,
I mean, you basically got your foreclosure complaint dismissed with prejudice. With prejudice.
right, but
And you're telling me that because you didn't get a copy of the notice for 10 days, that you just simply, well, chalk it up to another one, threw it aside and let it go when you didn't get a copy of the request for admission? And I believe, that may have been on the record. No, in his order, he mentions a request for admissions. The judge mentions, and you got a copy of that judgment, and it mentions a request for admissions, and you say, we never got that. We never got a notice of hearing. Oh, well, just put it in the file and let it go. Is that what you're telling me? What happened?
well, by the time the judgment was obtained, the motion for attorney's fees was received, and the attorney, you're right, did not file the appropriate motion to set aside the judgment.
You had a year to file a motion for relief from judgment. I mean, there were lots of things that you could do if you didn't have notice and had blown the 15 days or 30 days or even 60 days, right?
Correct, Your Honor, but what we can do is we can refile, even though it's filed with prejudice, it was dismissed with prejudice, because the mortgage foreclosure action continues to have payments due on them. You can go in with a new action because the evidence to prove that particular case.
This case that Wells Fargo has no standing to bring a lawsuit, so Wells Fargo can't bring another one because it's adjudication as a matter of right here that Wells Fargo does not have an interest in this mortgage. That's law of the case between these parties.
Well, there is a conflicting Fourth District Court of Appeal case that says that even, well, with respect to two dismissal rules where it's with
Well, I
prejudice.
understand the two dismissal rule and all that, but in this particular case, your client admitted that they did not possess a mortgage, did not have an assignment, and had not recorded one. And that's law of the case at this point in time between all of these people, isn't it?
That may be correct, Your Honor. You may be correct on that. I have not researched that point. But the 2 points that the trial judge looked at was whether there was sufficient factual basis for the legal description, and it was attached to the complaint, as Your Honor correctly pointed out.
What in this record, and in this record only, that was in front of the trial court, would establish that when you filed this lawsuit, you had any basis to believe that Wells Fargo had any right to sue anyone that was a defendant in this case?
The fact that the borrower's answer didn't raise the issue of standing, I think, is paramount.
So if I file a lawsuit against somebody, I just pick somebody on the street and I file a lawsuit against them. And if they don't raise standing, you mean I suddenly have a cause of action?
Well, not that they just didn't raise,
Pick them off the street, have
Your
a cause
Honor,
of action.
not that
If
they-
I'm lucky enough they don't file an
well,
raise standing.
I would agree with you, except that they did file an answer where they admitted that they...
They admitted they owed somebody some money. They didn't say they owed Wells Fargo.
Right, the loan servicer for Wells Fargo, America's Servicing Company. It's interesting that they didn't say, we do not owe money to Wells Fargo. They knew that America's Loan Servicing was the representative of Wells
So I can go
Fargo.
down the street and figure most people owe money on their mortgage, and if I file an action against them, as long as they don't pick out my name and say that I don't owe it to him, I can go ahead and file my claim.
Well, you
I
could.
mean, that's what you're saying, and suddenly I have standing to sue, even though I don't have anything recorded, I don't have any document signed, but because they didn't say, we don't owe him, they suddenly do owe me. Is that?
No, that's, I think...
That's taking a little far, isn't it?
It is, yes, Your
Well,
Honor.
thank you, I appreciate that.
Yes. 57105, Section 1, does say that if there are no material facts or law that could possibly support the claim.
So what we've got here, as far as what the trial judge had presented in front of him, evidentiary-wise, is a complaint that was filed, an admission that the plaintiff did not have the sufficient facts to support that complaint, and a dismissal of that complaint for the lack of having the material facts to support that complaint. As far as what this trial judge here in this fee motion, that's what he had in front of him.
Correct, in addition to the answer filed by the borrowers.
And if there is a complaint filed, and there is an admission that the plaintiff did not have sufficient material fact to support the filing of that complaint, why doesn't shall mean shall?
Because if you continue on reading the statute, Your Honor, there are two criteria that apply, and that is that there have to be no material facts.
And we just had that admitted. The judge just made a finding, they do not have the material facts to support the filing of this lawsuit. So what's the other one?
But then you have the conflicting fact where the borrowers didn't say, we do not owe the money to Wells Fargo, we're trying to work it out with their loan servicing
Well, they owe it or
agent.
not. If you don't have sufficient cause of action, sufficient facts to support the complaint, you can't file the complaint. That's what the law says. And when you were put on notice, you don't dismiss it. What the law's created is to say is, if in this situation you don't have all of your ducks in a row and you file it, even if they owe you the money, they show you don't have the ducks in a row, you dismiss it till you get your ducks in a row. And you didn't dismiss it. So they say, if you're not going to at least take care of cleaning up things, you pay the fees. That's what the shall says. You pay the fees. Whether you can file it again later, that's a different story. You pay the fees this time because you didn't clean it up when you had an opportunity to. That's why they give you the 20 days or whatever it is to file, to withdraw.
I understand, Judge, and if we had received the motion, then possibly we would
But
have
you
done
didn't
that.
go in and show anything to the judge that you didn't receive the
No, we did not, Your Honor. Again, sloppily handled, and I apologize to the court that it was handled that way.
The property owners filed a pro se letter rather than an answer, and they really never admit nor deny anything about Wells Fargo. And at least from this record, I can't find anything that connects America's Servicing Company, which is who they're describing, to Wells Fargo. Is there anything in here that shows any connection between these people?
Other than the fact that they were responding to a complaint by Wells Fargo and said that they were working with America's Servicing to bring their mortgage current, that's the only connection, Your Honor.
And we still don't have anything that would be in this. We have no information at all about if there ever really was an assignment to Wells Fargo or anything, I guess.
The status, there was an assignment, and again, they got the legal description wrong, and we're still trying to get the correct assignment from them with the correct legal description. Well, the bank is overwhelmed too. I apologize. They're
All right. Anything else?
No, Your Honor.
Mr. Conklin?
I frankly don't know what to say. I pulled out the notice of hearing, but it's not in the record. Judgments in Hillsborough are not sent out by the attorneys, they're sent out by the judge. If you look at the bottom of the final judgment, which is in the record, Daphne Tacco, and she was the attorney who signed the complaint, it's CC'd to her. At no time did they file a motion for rehearing, file appeal. As to your question to Mr. McSurdy about the servicer, in fact, the record shows the opposite, Your Honor. If you read a paragraph, I think it's 5 of the complaint, Wells Fargo said they were the servicer for an undisclosed owner with authority to act. And so that's why I said in the reply brief, what's the truth? That he claims now that America's Home Servicing was the servicer, but the complaint said that Wells Fargo was the servicer? Maybe this is some of the problems with foreclosure complaints. Thank you, Your Honor.
Okay, thank you. Next case is the Hunts.